chili was a little too old. That's leftover chili that you're there, and chili on with Monday night. It was a little too old.
For Monday night?
Well, I ate it. I woke up in the middle of the night.
If there's a
somebody messed up something with the landfill.
That's sort of,
And they were trying to come up.
yeah, that we, at least right here, so you're not blocking blocking people's viewpoint.
It's right in you, then you can't see.
I can't see the witness.
Right.
I'm not aware of any requirements.
I'm sorry.
We're all here, so we need to Zoom.
Not for me.
It looks like he's already hooked up. It is hooked up. It's on the way to the, people on the way down. But it's okay.
They don't need it.
Oh, no, I thought you said it's the extra hearing. Isn't that what we're doing? Okay. Another hearing?
It's
Got it, yeah. Okay.
okay.
Picture of the person.
I left your questions. Cindy, we talked about interpretations. Oh my God.
Yeah.
The judge is always here. So where did you guys go for dinner last night?
Oh, well, Miller Ale House.
Where are you all
The Hampton right next door.
So we just like walk around.
So the Miller Ale House.
In case we need to walk.
It's in Deer Lake.
Oh, no, you're down. Okay, yeah, that area there. Because I think we have 4 Miller Ale houses across the city. One's like literally across the street from where I live. There's,
We didn't for now.
well, Dan's got
It's right across from somebody's Oklahoma. Oh, yeah, it's right across the parking lot for that place.
Wallace,
yeah,
you dropped the ball. If you told me that last night, I'd be, we're leaving, we're leaving.
The only doubt,
Makes
Cole
sense.
Baines is their Georgia Bulldog. That's the only, that's the only.
Nobody's How are they not Notre Dame?
Southern girls, I guess.
They're really good.
So we're gonna hit the bearded man.
They do, they travel.
Very solid.
We'll finish that up.
Oh, yes. Dr. Holmes is up.
You don't want me to cross me?
I was scared of the ball, so I decided not to take it at the stand.
Strategically wise. She's been drinking coffee for a while. In preparation.
I was like, I really like it. I know that, John, but it's been a pleasure. Because there's no reason to we're just do your thing, I do mine, but we do it professionally.
No, I do appreciate it. And sometimes litigation gets a lot more active than it's not necessary.
Yeah. It just creates heat, there's no light there.
Yeah. I agree. Whatever happened with the Smiley matter?
It's still ongoing. It is. Yeah, one expert witness, the person who left was going to cover, and it was pretty extensive, so we bifurcated it, and that one's being heard February 20th. Okay. And additionally, one of the faculties, one of his brothers, unavailable. So,
Yeah, that it just we had just the cross section because Dr. Walton was he's hanging in.
I haven't seen it.
I spoke to him.
Hey, good morning. Nice to see you.
You too, good to see you.
I give him credit. He answered his cell phone while.
I'm waiting to retirement. Good. Okay. That's good.
issue for us.
Okay, that's good.
His testimony was he
Getting that involved.
completed an evaluation of 11 ways
No, it's just, I saw him doing that. Work on getting funding for like cars and stuff.
and they're claiming that
That's great.
the person who shot
He
him
has a passion for that.
medication issues.
But that's, but here's what's confusing, we used to. So we're saying, look, here's what we're talking about, you don't even know what you're doing up there, how are we really getting? In your case, you used to.
Right.
What is, what's, how's that very understood?
Well, they claim it hurt the defense because it was an NGI case. EO content was not NGI.
Okay.
But realistically, factual issues were
The court, this certain court divisions are D and for Duval County Court is now in session. The Honorable Judge Matt Murphy will preside. You may be seated.
Okay. Are you ready for us to call Madden, or are we waiting for Mr.?
Yes, Your Honor. May it please the court, we are ready. I believe Ms. Wright is back there. We're passing it to the line. She told me she was fine with the marches. You want to bring them out? It's fine with me if it's fine with the judge. Are you okay to bring them out? You want us to say it, or you want to?
I mean, that's up to them with him already in the courtroom. I'm not sure what the rule is about that. You can do it, then that's fine. Yeah, we're just going to pass it, right?
Yes, ma'am.
Okay, let's bring him out just for a second. We'll take care of Madden, and then we'll get right on Smith.
Your Honor, good morning. Dan Skinner on behalf of the state. Leon Madden is present for the court. I spoke to Ms. Wright just a few minutes before the court came out. And we're fine with passing this until tomorrow for resolution on the motion filed by the state. It's fine with the court.
All right, so that would be January 18th at 10 o'clock. I'm not sure which courtroom we'll be in. I don't think we'll be back in here, but we might be because they've already given it to us for the 3 days, and I don't think we're going to need it for Smith based on what they told me yesterday. So if you'll check with Lori Sobere later on today, she can let you know which courtroom.
Yes, Your Honor.
But tomorrow at 10 o'clock, okay? Thank
Thank you,
you.
Your Honor.
Thank you, Mr. Madden.
Excuse
You may. Thank you.
Thank you. That's exactly what I was thinking.
Okay, the only other case on the calendar is Mr. Smith. We're in the middle of his hearing on his motion regarding the 3.851 ineffective assistance of counsel. And he's on page 3 of the calendar, and we're proceeding to continue with the hearing. The defense announced yesterday at the end of the day that they were resting, at least for now, and so we're going to start with the state witnesses. Has your witness that was delayed been able to get here?
Yes, ma'am.
Oh, okay.
Thank you, Your Honor.
You may call.
And thank you for allowing us to start late
Oh,
this
sure.
morning. Her flight was delayed
Sure.
quite a bit last night. The state of Florida would call Dr. Heather Holmes to the stand.
Dr. Holmes?
Yeah.
I'm sorry, if you'd raise your right hand. Do you solemnly swear or affirm you will tell the truth, the whole truth, and nothing but the truth? Yes. And yes, ma'am, over here. This is a big bench, but yes, that's where you go.
Dr. Holmes, will you state your name for the record, please?
Sure, it's Heather Holmes, Holmes.
Will you go ahead for the benefit of Judge Cooper and review your educational background?
Sure. I was born and raised in Miami and then obtained a bachelor's degree in English writing and psychology from Marshall University. That's in Huntington, West Virginia. I then obtained a master's degree in psychology from Royal College of Maryland, which is in Baltimore, and then I obtained a doctoral degree from George Washington University in Washington, D.C. in clinical psychology. As required for that degree, you do a one-year full-time internship, pre-doctoral internship, and I did that as a psychologist with the Florida Department of Corrections, and that was rotating through 3 prison camps in Region 3, which would be Brevard Correctional, that is now defunct, that was our youthful offender camp, Lake Correctional in their inpatient psychiatric unit, and Central Florida Reception Center in Orlando. After that, in order to be licensed in Florida, you need a one-year full-time postdoctoral residency, and I did that under, he used to be the mayor of Miami Beach, who's also a psychologist, Dr. Lenny Haber, and Dr. Gustavo Fonte. That was in Miami-Dade County, and that's when I started on my own in forensics. I think I was licensed in 2005, so I've been doing this on my own since then, and then prior to within various prison facilities, because I did work for Maryland Correctional Adjustment Center, which is a supermax for the state of Maryland.
You are indeed licensed in the state of Florida.
I am.
As a clinical psychologist.
Correct.
So will you describe the state of your current practice?
So I would say about 85-90% of what I do is forensic work or evaluations, mostly for criminal. There's a couple civil cases that I have taken based on mental health or PTSD for individuals who are incarcerated or wrongfully incarcerated. So that's maybe one case every few years in civil. So everything in that 85% is criminal forensic work. The other remainder of my practice is private. I don't see therapy patients anymore. I do evaluations for ADHD, learning disability, giftedness.
Okay, and in your, both in your internship and your professional experience, have you worked with sex offenders?
Yes, so the first introduction really that I had was when I was at Brevard Correctional. As a youthful offender camp, they had more programming, and the state had sanctioned a 16-week sexual offender treatment course, and so I ran that under supervision with another doctor, and that was my first foray into that population. Since then, I've attended for continuing education units. I've contacted and met with individuals that are world experts in this, and now I do have a subspecialty in the evaluation of sex offenders.
Let me turn your attention to the case that we're here today on, the state of Florida versus Donald Smith. Were you retained by counsel, trial counsel for Donald Smith?
Yes, I was retained by Julie Schlacks.
And when was that?
2015. I don't think I have the exact date, but it was that year.
And for what purpose were you retained, Dr. Holmes?
So she, I believe, had other experts on the case, and she wanted a general psychologist to kind of go in and take a look and do an evaluation, get to know Mr. Smith, and just give her feedback.
Did you meet with Donald Smith?
I did.
And how many times did you meet with Donald Smith?
3 times, October 7th and November 17th of 2015, and July 8th, 2016.
And as part of your work on this case, did you also consult with defense counsel, with his lawyers?
Yes.
And was that Julie Schlacks with whom you conferred?
Yes, so I met with her several times. I do believe the first phase trial counsel, I met with him twice, with Ms. Schlacks as well.
And after meeting and evaluating Donald Smith, did you reach certain diagnoses and findings about Donald Smith?
I did.
And what were those opinions?
So he met diagnostic criteria. So for and I'm sorry, I wanted to double check because there's been a new version of the DSM-5, and so this was under the older version, so I wanted to make sure I didn't misspeak. Major depressive disorder, recurrent and moderate. Cocaine use disorder, severe in a controlled environment. Pedophilic disorder with the specification of sexually attracted to females. Antisocial personality disorder, borderline personality features, and then, of course, medically, he has hepatitis C and high blood pressure.
Did you ultimately testify in the penalty phase of Donald Smith's trial?
I did.
And did you share with the jury your opinions and the diagnoses of Donald Smith?
I did.
Did you explain to the jury in that phase of the trial what each of these disorders were?
Yes.
Did you explain to the jury what each of these disorders actually meant?
Yes.
And did you also agree in your testimony that these diagnoses all qualified as mental illnesses?
They do.
Let me now direct your attention to the defendant's criminal history and Jimmy Rice just more broadly. Were you asked about the fact that Donald Smith had been identified by the state of Florida in 1977 as a, quote, mentally disturbed sex offender?
I recall that, and we were certainly struck by that.
And you reviewed, in the course of your work on this case, you reviewed evaluations of Donald Smith that had occurred over the course of decades preceding your involvement in this case.
Yes.
And you also reviewed the information from various evaluations of Donald Smith.
I did.
And did you, in that review, find that at different times he had been identified, at one time, quote, a danger to children?
Yes, I recall.
Another time that he should not have unsupervised contact with children?
Correct.
And you also learned he had been terminated from an offender program for his refusal to actually participate in the program?
Correct.
Would you consider, or did you consider, this information as red flags in your work about his dangerousness?
Yes, I did.
In your testimony in the penalty phase, did you educate the jury about what Jimmy Rice civil commitment, what it is?
Yes.
And did you educate the jury about the end of sentence review process for sex offenders?
End of sentence in prison, yes. Yes, I did.
You'd agree that Donald Smith has a significant criminal history that has been mired with sexual deviant offenses?
Correct.
And the record that you reviewed revealed evidence of proclivity to reoffend?
Yes.
Did you review records, included in the records that you reviewed, did you include records of a 2006 evaluation of him by the Department of Children and Families?
Yes, I reviewed that.
And what did you see in that evaluation?
So this was an evaluation that was conducted on October 20th, 2006, and it was, again, he had almost the exact same diagnosis that I had reached, and he had reviewed the records, and he had described the difficulties that the defendant has in terms of these diagnoses. I think he did not have depression on there, but he talked about paraphilia, sexually attracted pre- and post-pubescent females, cocaine dependence, in remission in a controlled environment. In other words, you don't have access to cocaine, and antisocial personality disorder. So the individual that evaluated him came to the same conclusions diagnostically, for the most part, that I came to, reviewed the same information that I had reviewed. And the evaluation purpose was to determine whether or not Mr. Smith met the criteria for Jimmy Rice or to be considered a risk to where he would meet civil detainment criteria under Jimmy Rice and under that statute. And despite finding the same things and reading the same records that I read and talking about how dangerous he is, the author and examiner opined that he did not meet criteria for civil commitment.
When you were reviewing this evaluation from 2006, did it surprise you that despite these findings, the evaluator determined he didn't meet criteria for commitment?
I mean, to be frank, I was absolutely gobsmacked that the text of the report and the person you're describing is different than the conclusionary statement. went so far in the deposition with your office to say that there's a possibility maybe it was a typo, because the descriptions of Mr. Smith were accurate. It was exactly what I had noticed and seen and found, but yet with all of that information, he found him to not meet criteria. So yes, I was very surprised by the conclusion of that.
And in your opinion, was that a failing of the Department of Children and Families?
Absolutely. I mean, you have somebody under your watch. They argue to get out of a civil commitment and successfully are able to do that, but there's no treatment that was successfully committed with the exception of, I believe, a 33-day stay in a substance abuse treatment, and then he immediately went back and began using again. And your inhibitions are down with his drug of choice. He admits inhibitions are down, and to see that and to know that something like this was preventable, and I don't know if it was a typo or if this is actually what this individual opined and believed, but to see that something like this could have been preventable and that this was a mistake, in my opinion, on the Department of Children and Families was abhorrent.
And did you share, is it fair to say you were shocked by this?
I was absolutely shocked by this. The moment I read it, I picked up the phone and called Ms. Schlacks and said, I need you to read this. And we had extensive conversations. You know, she doesn't do Jimmy Rice evaluations, but she had some knowledge, and I said, I just can't even rectify the conclusionary sentence with the totality of a 22-page report.
So in a moment, I'll talk to you a little bit more about your conferences in more detail with Ms. Schlacks, but before we get to that, I want to talk to you about 2 points in fact with you. In your evaluations of Donald Smith, did he ever demonstrate or exhibit remorse or convey remorse to you?
No. What he said was he has no idea why he did this, but he did say he was very angry that this little girl followed him and got in the van because he's a convicted sex offender, and he was mad at her for putting him in that position.
Did Donald Smith ever disclose being the victim of sexual abuse to you?
No, he did discuss or disclose an incident when he was younger with 2 boys that were a little bit older than him, where they were masturbating. It was a sleepover each other, and they asked him to masturbate. And so that was the only story he told that had any sexual component to it. But when I asked him if he had been sexually abused in the past, he had said no.
Yesterday, Dr. Butler testified to the court that you communicated with her that Donald Smith had conveyed remorse to you. Is that true?
That is not true.
She also testified to the court that you shared with her that Donald Smith had disclosed to you sexual abuse. Is that true?
No.
She testified that you communicated these things to her via email correspondence. Have you had an opportunity to review your email correspondence with Dr. Butler?
I've reviewed it, the correspondence that I had with her, but I didn't review it with her. I just want to make sure that I'm clear on the answer.
Thank you.
Yes, I reviewed the email history that I have with her on, and I believe we've had 3 clients together. So yes.
And in light of your testimony, then I think it's fair to say there are no emails which would indicate that you have conveyed to her that either he exhibited remorse or claimed to have been a victim of sexual abuse.
That is correct. There are none.
So during the penalty phase of this trial, I cross-examined you. Do you recall that?
I do.
And I asked you during that examination about your deposition testimony where you testified that you had found nothing mitigating about Donald Smith. Would you expound a little bit on that finding and in the context in which you made that finding?
Sure. So when you're looking at, for the death penalty cases, the 2 statutory mitigators, and I did go into detail in the deposition about this, you know, one of them is not being able to control your actions, and Mr. Smith was very forthright that he did not feel he could control himself. But the reason for that was not an underlying mental illness. You can have pedophilia and still control it. The reason for that, from what he cited, was the crack cocaine use. He had been using what he said was very heavily for 3 weeks, and then immediately preceding this homicide, he went into the bathroom of Walmart and had used crack cocaine. So in a general sense, would he have met that? Yes, but it's due to voluntary crack cocaine use as opposed to inhibitory difficulties due to a mental illness, or it would be up to a neuropsych to see if there was like a head injury that then would have impacted his impulsivity. So when I rendered that testimony, it was in reference to the two statutory mitigators. In terms of the third one, which is kind of a catch-all, there were some minor things in his history, such as he talked a lot about anxiety as a child. I equate it to being an Army brat. His first stepfather had moved several times due to job, and so that can be very disruptive, and Mr. Smith talked about anxiety at school and with other kids and going into a new environment. But again, he denied physical abuse, he denied sexual abuse. The first few years of his life were not flush with money at all. His mother, she was a single mom and she struggled, but he talked in glowing reviews about his mother. His first stepfather was cold, and his second stepfather was a psychiatrist, so their, lot in life went up financially. So again, the two statutory mitigators, I didn't see those being applicable to him. The one that is kind of a catch-all, there's some minor anxiety growing up, and definitely a lot of moving, which can be disruptive to a child.
And when we talk about that catch-all with mitigation, you are aware that trial counsel called, in addition to you, a social historian, a mitigation specialist to speak as to that catch-all.
Correct.
So let me now turn your attention to your discussions and conferences with trial counsel. So you've mentioned that before you testified, you conferred with Ms. Slacks on more than one occasion.
Yeah, several occasions, yes.
And in those discussions, did you discuss with her the potential ramifications, the pros and cons of providing testimony in a penalty phase?
So I discussed with her what my testimony would look like, and she evidently is very well schooled in this because she knew the pros and cons. The cons being, diagnostically, what I have to say about him is not possibly helpful, but at the end of the day, she looked at if there would be any pros, and she was just as floored as I was that the state of Florida, the Department of Children and Families, had this opportunity, and they made the wrong call, even though they had all the information to make the right one. And so she went back and forth and weighed the pros and cons, not just in one meeting, but in several. And she said she was going to talk to first phase trial counsel and get back to me. She needed to think about it, and she also needed to talk to the defendant. He's very intelligent and was involved in his defense and the preparation of it.
So you'd agree that trial counsel was fully apprised of what your testimony would be?
Oh, yes, no, she knew. Well, and she asked me, she said that the judge in the case was asking for a report, so she had the report, and at that point in time, in black and white, if she changed her mind to call me, she didn't have to turn over the report.
Ultimately, the decision was made to call you as a witness.
Correct.
And would you agree that this was made after much deliberation?
I mean, I have a vivid memory of watching her almost wring her hands going, this could go either way. I mean, she basically said, I can't put on nothing. I mean, they're the same state that screwed this up and could have protected this little girl is now trying to execute him. And if I don't put you on, then it's hard to explain that report and what that means and how this could have been prevented. She goes, but if I put you on, you're going to talk about who he is, what he's done, and what his diagnosis is, and that's not good. So she did. I mean, she was, I have in notes that she, we talked about it, and then she said she needed to discuss it with first phase trial counsel, and that eventually she would need to talk to Mr. Smith about it, and she would get back to me.
And ultimately, you understood the strategy or the goal of your testimony was to further the argument that but for the state of Florida's failures, this would not have happened.
Correct. The idea being, this is somebody who has impulse control. He has not been able to kick a major crack habit, which lowers his impulses, and he has a high sex drive, and he's attracted to prepubescent females. So if the state has all that information, and that would have prevented this rape and homicide, and they elected not to do something about it, then some of the onus and blame lies with the state. Maybe not the state attorney's office with DCF, but her belief was she needs one juror and only one. And so even if you dislike Donald Smith and you dislike what he did, she was hoping that somebody would understand on that jury that the state of Florida made the error by not locking him up when they had all of the information and resources to do so.
Thank you. May I have just one moment?
You may.
Okay, thank you. Nothing further at this time. Thank you, Dr. Holmes.
Sure.
Any cross-examination?
Yes, sir.
Okay.
Good morning, Dr. Holmes.
Good morning.
You indicated in your report that among other documents, you also reviewed an abbreviated biopsychosocial chronology put together by Dr. Butler?
Correct.
Okay. And did you note on that report that Dr. Butler wrote in 1964, this is on page 3, at the age of 8, Donnie is sexually molested by 2 older neighborhood boys. They forced Don to masturbate and perform oral sex on them.
Yes.
Did you also note that in 1974, when he would have been approximately 18, Don is raped by 2 male inmates while being housed at the Duval County Jail?
Yes.
Would you agree that violent sexual abuse is something that could be considered a mitigating element?
Yes, absolutely.
Is there a reason why you didn't indicate that on your report?
So what happened was when I spoke with Brooke about that, because we did have a phone conversation, he denied it to me. So whatever he told her, she was going to have to testify to. But when I specifically asked him about sexual abuse, he denied it. When he relayed the story to me about what happened, he wasn't 3 years old. He described it as them being only a few years apart and about him masturbating himself. He did not disclose to me that he was asked to perform sexual favors on these boys. So the discussion with her was, he didn't tell that to me. And you can rely on what a mitigation specialist finds from individuals that you don't interview. But if I interview somebody, I need them to tell me that. And he did not. In fact, he said something very different.
Okay. And if you do find a conflict between what is reported to somebody else and what is reported to you, do you ever go back and speak to the person to try and clear it up?
Yes, sometimes. And again, when she and I spoke, this was very late in the process. And you'd have to ask trial counsel, but there was a point in time in which I was a little bit kept in the dark. I don't know what the other examiners found or didn't find. And at this point, Ms. Schlack started meeting with me or emailing just me and not including Brooke on those emails. And when I talked to her about this, she said, I want you to focus on the DCF issue, and I'm going to have Brooke Butler or Dr. Butler talk about the social history and what she found.
Okay. So in your opinion, you were kept in the dark by Mr. Smith's counsel?
Not about what Ms. or Dr. Butler had found, but about whether they were going to use a neuropsych or anything like that. She wanted me to focus specifically on the narrow issue of the DCF, what I would say is mistake.
And you were also informed that a neurologist and a radiologist and a pharmacologist had been retained to opine in Mr. Smith's case?
So I knew that she had a lot of experts. I had told her that I wanted a neuropsych to take a look at him because he talked to me about these head injuries. And so I do believe there was another doctor involved. Briefly, he reached out after he met and evaluated the defendant. What was relayed to me by defense counsel is that there was nothing discovered that would be pertinent.
And that you were informed of that by defense counsel? Was that Ms. Schlack's?
Yes.
Were you aware that there were imaging studies done of Mr. Smith's brain?
I'm sorry, could you repeat that?
Were you aware that there were imaging studies done of Mr. Smith's brain?
I knew there was a neurologist But no, I didn't know what studies were done or what the results of those were.
And obviously, you didn't see the imaging studies.
I could see them and still not know what they mean, so no, I did not see them.
You're not a neurologist.
They were colorful maybe, but that's all I know.
So if they had found atrophy there, for example, you wouldn't be able to recognize it even if you did see it?
I mean, if it's profound atrophy, I think maybe a layperson could see it. But no, if there's atrophy at a neurological level, that's outside my wheelhouse and pay grade, so I wouldn't know.
But you did recognize that Mr. Smith had been diagnosed, in fact, diagnosed by you, with several conditions that are recognized by the DSM, correct?
Yes.
And those are not voluntary conditions, are they?
What do you mean by voluntary?
I mean, they're not something that someone goes out and catches. They're something that someone is either born with or is inflicted on them, correct?
Oh, yes, I'm sorry, I didn't understand what you were saying. That's correct.
Okay. And obviously, they have caused harm to members of the community. They've also caused harm to Mr. Smith's mother and his son and Mr. Smith himself, have they not?
Of course.
Would you not then consider those mental health conditions to be mitigating?
So the way the statute is written, I didn't feel like the two main statutes were met by the conditions he has. I do think, having what I talked about earlier, having a lot of moves, having some anxiety as a child, that those, fall under the general catch-all mitigators. When it comes to, like I said, the crack cocaine use, that's voluntary. So would that have impacted his ability to control himself on the night that this happened? Absolutely. But again, that was something that he elected to do. So can he help that he has depression on and off? No. Can he change his personality with intense therapy? You can bring it down a little, but that stays the same. The addiction can be treated. And so again, no, he did not go out and get these, but at the same time, I didn't feel like what he had would have met the criteria for those two statutes.
You're aware, though, that mitigators are not limited to the statutory mitigators?
Yes, when I said that I didn't find anything mitigating, it was those two statutory mitigators. The other...
You didn't specify that, did you?
I'm sorry, say again?
But you didn't specify that, did you? You just said you didn't find anything mitigating.
Correct.
What you really meant was you didn't find anything that met the specific criteria of the two statutory mitigators in the statute.
Yes.
And you never testified before the jury or in deposition that you had found other criteria that were mitigating but did not meet the statutory definition of mitigation.
No, I wasn't asked.
And that's the reason you didn't inform the jury of that, because Ms. Schlax didn't ask you?
Again, she had Dr. Butler testifying, and because Dr. Butler had gone to see him more and spent more time with him and had information that he had denied to me, she was going to do the things that were mitigating were in the social history that would be under that catch-all, and that was going to be handled by her.
But when you were asked in cross-examination about whether or not you found any mitigators, and you indicated you had not, Ms. Schlax had the opportunity in redirect to ask you if you were talking about statutory mitigators or mitigators in general, correct?
I would assume so, yes.
And she didn't do that?
Not that I can recall.
Okay. You indicated that Mr. Smith had not expressed any remorse about the incident in question?
Correct.
You were in communication with Dr. Butler by email, were you not?
I was.
Did you previously go by Heather McKean?
Oh, that's married name?
Oh, okay. I just recently received some copies of emails between yourself and Dr. Butler, and I wanted to talk to you about those. I don't know that the state has seen them. Open, please.
We've not been provided that in the course of discovery, so we would have an objection.
It was very recent that I received them, Your Honor.
Well, what does that mean? Today, yesterday, this week?
Yesterday.
Yesterday? Have you printed them where they can look at them?
I have not. I don't have access to a printer here that I can do that. I can show them to them now.
Would it be easier if he forwarded them to you? Would you be able to?
Sure.
I mean, yeah, if they're forwarded, we could review them on our phones.
Okay.
That might be easier, then they can both look at them at the same time and then proceed with whatever argument they might have.
Judge, we'll need a moment to review them, and these were received yesterday. Counsel has my email address.
Okay, yeah, I know, and you might have that argument, and I'll listen to the argument. I want you to see them first. Do you want me to take a short recess to give you time to look at them?
Yes, let me see if they're received, because of how they're being transmitted. I haven't received anything yet. Cool.
Are these the same emails about which she testified? She testified that there were a couple of emails back and forth, or is that what you're talking about?
I believe so.
Do you have a date of the email?
Let's see. Looks like the exchange, one exchange is Tuesday, November 17th, 2015.
Just so you know, I still haven't received it.
Leslie.
Your Honor, it might be good to take a break. We can go into the jury room and I can try to read them off of Mr. Pope's phone. I'm still not receiving.
Okay, wait a minute. If he emails to you, do you have a way to print it? If you would walk up to the clerk's bench, please, and let her give you how to email it to her, she can print it. And we will go ahead and take a 10-minute recess. If we need longer, that's fine. Y'all just let me know when you're ready. We'll be in recess for 10 minutes.
Can I step down?
Yes, you can step down. You just can't talk to anybody about your testimony. Just let me know when they're ready.
I know you said the witness can't speak with anyone. Can I get the spelling of her married name?
Doctor, can you give her the spelling of the, I'm not sure who she needs. She needs the spelling for the record.
I don't know if there's a problem with the city firewall, but we're still not receiving it. And I've received other emails since. November 2015.
The mic's on. Up 3 or 5, smaller, it's just better. Sit on the ground. I don't sit on the ground. I just lay back, but I don't sit on the ground.
Where's Judge Cooper? Does she have her little lift in the chair? No, she needs her lift.
I had one by accident. I'm not worried about the remorse versus his name's in it, but no, I mean, it is what it is, the fact that like
What about that?
Did she ever testify?
No, I'm pretty positive, but I'll look. That's how I remember. I remember other people talking about these different colors.
However, you certainly can't go to watch him become so
About. Oh, no. Okay. Somebody say and so then I'm going to ask the court to give me a certain amount of time after the writer's transcript. And so I'm just want an understanding. It's not, I'm not questioning. Okay, it's more of just making a technical inquiry. Information, I guess, but not pushing it. So, okay.
Just said everything back. So, yeah.
I'm not trying to be, I don't care. Yeah, yes, I don't care, it's not that, I just want to know, so when I address the court about it, I have an understanding what I'm asking.
Yeah, that would be great.
After you're done.
Yeah.
If you're done, then I have my time to write, because I can't write it correctly.
Sure, yeah, if I could get 30 days.
Okay, all right. Thank you.
How are you using it for mitigation?
Wait, I'm not following up. Right.
She says, yeah, can any have all person's not mitigation? Judicial sense, yes. She was saying mitigate. So, that the statutory mitigators that apply to mental health. And she so there was clarification.
recollection.
Julie did go back.
What was the date of this testimony, because I have it pulled out. Doesn't matter.
It was the first mitigation was 1200. It's the first day.
Try to check it out. Oh, because we're putting the island in, so there's a trench with dirt. I mean, electric. Lines are all. Line. It'll be nice when it's done. It's gonna be really good. I mean, I do in an office, and I've got a carpenter, so I can share his information with you. He's good. He did. He moved and Murray did it. He was a teacher, he converted to a bedroom that didn't have closet space, so he has done two closets. He's talented. So I'll share his information. I've got to get it from Jason. He's going to take a trip.
Yeah, we are. Speak of my mother taking away from next week. So we have people coming out to see if I was going with us.
Nice.
All rise. Court is in session.
Thought you were going to come tell me. Be seated.
I'm having a hard time hearing you. I can't see you.
Oh, okay. I'll move this. Huh? All right, Mr. Khalil?
Your Honor, I believe defense counsel has hard copies of the emails they were referring to. We would just ask that they were not previously provided in discovery, although they were received on Monday from Ms. Butler, or Dr. Butler, who testified about them yesterday. We would ask that the witness be given the opportunity to review the email chain because it is from 2015. So obviously it's 8 years ago, or not, almost 9 years ago now, so that she would have the ability to refresh her recollection, and then they can proceed with the questioning. But these were not previously tendered
All right.
for the witness.
Okay. Any objection? All right, if you'd provide her a copy to look at, and she'll let us know when she's had an opportunity to do that and is ready to proceed. You may. You ready?
Yes.
Okay, you may proceed.
This is your copy or mine?
That's the only copy I have.
Okay, go ahead. You'll just have to get specific about the dates because I didn't write them down.
In 2015, you were communicating with Dr. Butler by email, were you not?
Yes.
And specifically on Saturday, October 10th, 2015, you sent an email to Dr. Butler. It says, also, did he mention his first sexual experience to you? He was 9 and 2 neighboring boys were 13. No penetration, but still disturbing.
Correct.
Do you recall testifying in direct on February 20th, 2018 with Ms. Schlacks, and you described things that are mitigating as if you were, raped by your uncle, God forbid, that's mitigating?
Yes.
Would you say that disturbing sexual contact between Mr. Smith and neighbors 4 years older than him that you described as disturbing would also be mitigating?
Yes, and again, that would fit under that catch-all. He went into detail with Dr. Butler, which is why she was going to talk about that.
You also had an email exchange with Dr. Butler, and on Saturday, October 10th, 2015, you sent an email to Dr. Butler indicating check that. On November 17th, 2015, great, he is also speaking very openly about his attraction to both adult women and female children. He is also expressing remorse for what he did, although we didn't go into detail. Do you recall that?
Yes.
And that was referring to the crime with which he was convicted.
Yes, and so that I'm clear, I do apologize. I reviewed these on my phone last night, and there was an expounded portion that I didn't look into, so I don't want to speak ill and suggest that Dr. Butler and I had not ever emailed. I didn't see the one that you're specifically talking about, so I want to make sure and clarify, to the court that there were emails. It was very early on, more early on in the case. But that being said, so that I am clear with the court, I neglected to expound it as I was trying to do this on my phone, so I do apologize. So yes, there are 2 emails that were pertinent to what you were discussing that Dr. Butler and I had.
And in fact, he did express remorse to you.
So he did initially, and then when he started talking about it, he then began blaming the victim. So what I wrote and what Brooke and I had talked about at that point in time was not after I had completely finished in meeting with him and seeing him.
So you emailed this to her in the middle of interviewing him?
Well, I met with him more than one time.
Okay, so on this occasion, he expressed remorse, but on a later occasion, he expressed anger at the victim.
Correct.
Okay, so the remorse part didn't make it to your report, but the anger part did.
Well, it kind of undoes remorse. You can say you're sorry for something, and he did initially. He then later on blamed the victim.
Would you agree that you can do both?
Sorry, say again?
Would you agree that you can do both? You can be remorseful personally and also be angry at another person as well?
I mean, you can. It's just in context. To have remorse, you have to have ownership. And he was removing ownership from the equation. So in general, can you have both? I would say yes, but when you're looking at a child, in other words, you can have remorse that somebody died and still blame them if it was manslaughter because you got in a fist fight at a bar and somebody fell down and hit their head. You can be mad at the person because you got in a fight with them and still feel remorseful that your actions led to their death. But when you're blaming the child for their own death, it really does undo it in my mind, in my opinion.
And did you explain that nuance to the jury?
No, I mean, if I was asked, I would have, but no, I did not.
And you weren't asked it by Ms. Schlax, correct?
No, and again, the way things were divvied up, I guess, was that I was more focusing on the DCF problem, which I still believe was a problem, and there's certainly responsibility on the part of the state. But the social history, because Dr. Butler had met with him more, and some things that he denied to me, perhaps with her he had gone into detail, she was handling that.
But obviously, your responses in cross-examination that were extremely harmful to Mr. Smith, those were also something that you were paying attention to, and Ms. Schlax should have been paying attention to, correct?
I mean, like I said, Ms. Schlax was aware of what my testimony would be, discussed it with first chair counsel. I apologize, I know it's Chuck, and I'm so sorry, can't recall his last name. Outside of my presence, and she was going to, discuss it with him. She said she was going to maybe even speak to a colleague, and at that point in time, it would go to Mr. Smith and see if he wanted me to testify. So, the negatives that would come out, really she was weighing whether or not some of the negative things I had to say in terms of my evaluation of him and my meetings with him would be more problematic, or whether or not putting forth this, what I see as an egregious error on the part of the state being DCF, whether there's any benefit to that. So that was what she was weighing. So she knew my thoughts and opinions about Mr. Smith. It was whether or not she thought there was any value in trying to get just one person to recognize the responsibility the state has in this.
Did she ever ask you to temper your opinion regarding his lack of mitigation?
No, and I would not, if an attorney asked me to temper something, do that.
Did she ever ask you to explain your distinction between statutory mitigation and mitigation in general?
No.
May I have a moment here?
Dr. Holmes.
Wait a second, he's asked for a moment.
Oh, I'm sorry.
Oh, no, okay, you may go ahead.
Dr. Holmes,
Your opinions about Donald Smith actually go farther than that which was elicited by Ms. Schlax during penalty phase. Is that fair?
Yes,
In fact, you believe he's a sociopath.
I do.
And in your decades-long career, you've come across how many sociopaths in your work?
I've seen probably close to 2,000 inmates or defendants, and I have seen 5.
5 who would qualify as sociopaths?
Yes, and let me explain that is a step further than antisocial personality disorder.
And you shared this opinion, your opinion, that Donald Smith is in fact a sociopath with trial counsel.
I did.
Had she on redirect asked you to explain the nuance in what you described about remorse, expressing remorse literally and actually demonstrating remorse, had she asked you to explain that nuance, could that line of questioning in fact have elicited your opinions about his sociopathy?
Yes.
And
Oh, I'm sorry.
I'll overrule the objection.
I'd ask you to explain why.
So, antisocial personality disorder, individuals sometimes don't have remorse, but really it's behavioral. There are things within the DSM-5 or 5TR, or all of the versions, that are mental illness, schizophrenia, bipolar, depression, all of the things that general lay public knows about. Personality disorders, there are some research recently that there can be some genetic predisposition, but really the totality of these individuals are kind of made that way. when you look at antisocial, these are individuals usually, and you have a higher frequency of them in the prison population than we would in the general public, but antisocial personality is somebody who doesn't care perhaps about what happens to another so long as they can get ahead. And again, on a continuum, you can have a little bit of that because you want to, get ahead in law school and you need to study and put yourself first, and maybe you're not attending as much to your marriage or your children if you're married and have kids at that point in time. It doesn't make you a sociopath or have antisocial personality. These are individuals who engage in behaviors, they've been traumatized or they've had difficult upbringings, and they just engage in criminal or impulsive, reckless, risk-taking behaviors. Individuals that are sociopaths, that is a step further. There is an enjoyment of the game. In other words, it's not about whether you win the chess game, it's the joy and fun of manipulating and moving the pieces across the board. And usually the thrill is at the expense of others. So when you look at somebody who has antisocial personality, it's more cold-blooded, need to get ahead. When you look at somebody who is a sociopath, they actually have an enjoyment of others' difficulties. And remorse in that context is not something that an individual with sociopathy has the ability to attain. They can state it, and part and parcel to sociopathy is that these individuals are incredibly charming.
So the trial strategy discussed with you by trial counsel, the purpose and the goal of your testimony was to highlight for the jury the failures of the system in allowing Donald Smith to be walking the streets free. Is that right?
Yes.
That strategy decision obviously came with potential risk.
Sure.
And balancing the benefit, if you will, of highlighting that failure of the state and walking the line of making sure the jury didn't hear potentially the most damning of your opinions, was a decision or a walk that trial counsel had to make, correct?
Yes. So the concession is, if you put me on the stand, I can't not give you my diagnostic opinion of him. Antisocial personality disorder is in the DSM-5. A sociopath, that's not. And sometimes they're used interchangeably in layman's terms, but they are very different. And if you ascribe to a particular theory of personality disorders, which is what I was schooled in, then there is a distinct difference between these individuals, and they're extremely rare. And so when we talked about this, her goal was for me to narrowly give my opinion on his, first of all, he's bright without exception, despite a lifetime of crack use. This is an intelligent man. So she wanted me to give my impressions of him, give the diagnosis, if I didn't find anything in terms of the statutory mitigators, say that, but really the focus of the testimony was on what I believe to be an egregious mistake on DCF.
May I approach the witness?
You may.
Dr. Holmes, let me refresh your recollection, and I'm showing you a transcript of your penalty phase testimony, and I've asked that you
Go to the redirect examination, which begins at the bottom of page 1609, and go ahead and take a moment to review the inquiry of you on page 1610. And let me know when you've looked at that and finished reading.
Okay.
Okay. Okay. In fact, on redirect examination, after I had cross-examined you, Ms. Schlacks asked you to expound on what mitigation means to you. Is that correct?
Yes.
And did you in fact answer her questions?
Yes.
And that was in front of the jury?
Yes.
Let me close my questions with just a couple questions about your conferences again with Ms. Schlacks. When the two of you, or when she was debating and considering whether or not to call you as a witness, she explained to you that she was going to confer with her client, Donald Smith, about his wishes as well. Is that correct?
Yes.
And she got back to you after we had met with Donald Smith to tell you that the two of them had discussed both the pros and cons of potentially calling you as a witness in the penalty phase, and that it was his express wish that you be called.
Yes.
Nothing further.
Anything further on cross-examination?
Did you inform Ms. Schlacks prior to trial of your opinion as to Mr. Smith being a sociopath?
Yes.
So, just so I understand, Ms. Schlacks put you on the stand, exposed you to cross-examination, and the risk that you would have testified that her client was a sociopath. Is that correct?
Yes.
Nothing further.
Anything further from the state?
No, Your Honor.
May this witness be excused?
Yes, ma'am.
Thank you for your time. I understand you've got somewhere else to go for tomorrow.
No worries, and thank you for your consideration this morning.
No problem. I figured anybody flying today was going to have issues.
Oh, my goodness. I should have just drove.
Your Honor, the state has no further testimony to present.
Oh, okay. Anything further from the defense? Did y'all want to do closing arguments, or did you want to do written closing arguments, or how did you want to do that?
Well, I had anticipated, because generally in these cases with so many different claims, we do written closing arguments. And I would ask for what standardly we get is 30 days after the court reporter provides us with the record. Or I guess you'd file it so that everyone has it, and then once the record's filed, then we have 30 days.
Any objection?
No objection, Your Honor.
Okay, that's what we'll do then. We'll have written closing arguments. We'll wait for the court reporters. Our court reporters are very good about preparing transcripts. Once that's ready and filed, then the defense will have 30 days and the state will have 15 days after that to respond. Did you want to add something? Okay. Anything further that we need to do?
Okay, so this is a technical issue that I might get asked for the office. Is the court ordering the court reporter to prepare the record? Because sometimes my office might be asked how it's billed, just so I can answer them. I don't know how that works.
How do I normally do that? Well, no, I don't think normally the court orders it, do they? Not normally. The party that wants it's normally who orders it.
Okay, I'll look it up.
Okay.
Thank you.
That means y'all will order it?
We'll need it for the closing.
Right, okay.
I know they're going to ask me, so let's ask them. I figured we'd find out right now.
No, that's fine, that's fine. Okay, anything further?
Nothing further from the state, Your Honor.
All right, then we'll be in recess. Thank you all very much for your time today. Ten. And it's finally, after years, on the sentence.
The order already been done to transport him back?
I don't know. I'll check with Ms. O'Brace.
Yeah.
I'll check with
I think it
her.
was all within the one order to have him here as quickly as possible and then return.
I think it was too, but I'll check with her when I go upstairs.
Thank you so much. It's been a much better experience.
Oh, good. That's good to hear. Thank you.
Get more too. I'll find out which courtroom.
It's going to be moved back to 305.
Oh.
Mr. Cleo, could you let Mr. Skinner know we'll be back in courtroom 305 tomorrow? Please, thank you.
Okay. It's 10 o'clock and 3:05.
No Red Cross plea, I'll go to the plea dialogue and sentencing.
Great.
I don't think it's time served, but I hope so. thrilled with that.
Okay.
I agree.
Yeah.
They don't need to hear that.
No.
So we'll be real quick.
Good. Yes. Come on, Judge.
So
Thank you.
glad to see you.
Thank you. Love seeing you. We all do. I was happy I got to come be with you.
I'm happy too. So when do you see Nancy again? How often do you go to her?
You know, I've only been twice, and I didn't realize, because what I do, I try to color my gray, and it comes out blonde. And then after you do it, to me, I get too blonde. So I go to her for low lights. So she said it had been, I'm sorry, go ahead.
And this, y'all know I'm trying to talk to you.
I love that. Anyway, it had been 10 months between each visit, so I'm going to try to go more often.
Yes.
I really like it.
Yeah, she's great.
It's no sound. I think you get a file. So like we ordered it every week.
So I'll,
Yeah.
decide about there, doing that.
Yeah.
Great, what do you want there?
So, let's see. I'm going to start coming in once a month, not for court appearances, but for some, a history project we're going to work on. The first time I go come in will be February. They won't be ready by then. Maybe March, but if not then, maybe April 3rd when I'm coming back in.
Okay, yep, I think
For
that's,
Jasmine O'Neill, which is going to be a hearing. So, yeah, so just take your time and tell your dad and mom I said,
okay, will
tell them
do.
it's the best thing in the whole thing in the whole world. Thank you. Like seven kids.
Yeah, especially when I'm here.
Any kids. It's just different.
Yeah.
It's a joy, pure joy. Whereas with your own children, the joy is mixed with so many things you have to do.
You actually have to deal with their problems. So that's why I enjoy so much being an uncle to,
Yes,
it's just like,
okay.
hey, we're having fun. Guess what? When you
don't know.
when you have a temper tantrum, we just give you back to your parents.
Right.
So,
It's very similar to that.
yeah, so,
But anyway, I want him to know I'm thrilled for them and can't wait to find out who the little one is.
Yeah, yeah.
What the little one is. And
yeah.
all that. If it's a girl, Mallory's not a bad name.
My wife already has the names for our prospective children picked out, so I'm just like, please don't pick one of those. Please don't pick one of those, because I know she'll be upset. So,
Well,
yeah.
the chances are they will not pick the same.
I know, but we had some friends do it, and she was like, well, now I gotta change it. We'll find something else if they do. So, but anyways, it was nice seeing you. I'll schedule April 3rd, and hopefully maybe we can get that, maybe not. So, but all right, Judge, have a good day.
But she's explaining.
I just want you to know, you reach out to me, and I don't know how to do that.
No problem. And I'm getting what we want. And Jake, give you our Mr. Austin.
He gave me an investigative.
Yeah. If there should be
Jeffrey, Mr. Chili Dog. Will you bring this up for me?
Yes, I will. Yeah.
Okay.
Let me do the paperwork on Smith when we come out here, and I'll bring it later.
private package like,
Want me to take it to the back or leave it right here?
You can leave it there.
Okay.
And then, we're doing Madden in here tomorrow at 10?
In 305,
Okay, 3:05.
yeah.
Okay.
And he's going to withdraw his plea, replea, and get rid of it. It won't take long. Like you said, he wanted to get it from the press, which is correct.
Yes, I agree. This ended a lot quicker than I thought it
It
would.
did.
Good job, Judge.
If I'm not there, just leave it.
but you know, yeah. Because it's just that I love this.
I know, he's happy, he's with my mom.
Right, there's all that.
It was nice working with
You
you.
still miss him. My mom died a year ago, so I know exactly how you feel, but it was, and she really, so I have that concept. Yes. Thank you very much. Thank you.
Thanks, see you.
Anything in here?
Yeah, you're fine. Okay, we'll see you later. Thank you, Mark.
There's one in the,
I just heard them talking about it.
So, 30 days, 15 days, 30 days.
they locked down 406, they're done. What the abrupt ending that I wasn't expecting.
Oh, I was. They said yesterday that the state only had one, and they didn't have it anymore. Oh, that's true. I mean, you think, she said she might have thought, the defense might have recalled their witness, Brooke.
Oh, the rebut?
Yes.
Wait a minute. So it's 4 or 5? I think they're at lunch.
Washes away.
I think 4 or 5 still up, or they at lunch? We got to go home. I got to go that way. With my son this year.
Yes, yes.
They're up on.
That's what she told me. Are you there tomorrow?
I was scheduled to come with us on
This is off though, but it's a theme from 11 o'clock. But it runs about 30 seconds behind.